Thank you very much.
Yes, thank you. Good afternoon. Please, next slide. So here you see what I'm going to talk about, the Brexit state of play, then exports to Great Britain, imports into the EU from Great Britain, the preparations which have been done in the UK, preparations in France, in Belgium, in the Netherlands, and then I will talk about the special situation of Northern Ireland with regard to trade in goods. Next one, please. So Brexit state of play. So as of 1st of January, Great Britain will be treated by the EU as a third country in terms of customs, VAT, excise, foreign trade law and statistics, and of course also only with regard to goods, because that's the topic of my presentation. With regard to trade in goods with other EU member states, Northern Ireland will be treated as if it were another member state. So the code XI, or depending on the regulation, the code UK, and in brackets NI is needs to be used. The hot question, will there be a free trade agreement? The issue then is what changes if there is one. Then there will be duty-free access for products meeting the preferential origin requirements. There will be additional tasks related to the documentation and proof of origin. And we have to bear in mind that not all goods will meet the origin requirements, which means for those goods not meeting the requirements, customs duty must be paid. And there is a statement by the EU Commission, there is no plan or possibility for a grace period. Next one, please. What is it what prevents or makes it so difficult to have a free trade agreement? There is a fundamental difference of approach. The EU wants a level playing field and wants a comprehensive agreement on future cooperation. And the UK wants to ensure sovereignty under the slogan "Take Back Control." So that makes it difficult for both parties to meet. Next one. Here I have put in a quote from a journalist from the Financial Times, which shows that many people don't understand that even if there is a free trade agreement, it doesn't necessarily mean that all goods made in the UK are then duty-free, because if too many components were used from third countries like China, then they might not be able to fulfill the origin requirements. Next one, please. And here I have taken from the draft of the free trade agreement, I have taken just 2 lines from Chapter 85. That's these headings are electrical motors and parts for electrical motors, to show you that the rules would even be a bit more complicated than what the journalist said in the previous slide, because in fact, quite often we have 2 criteria. One is change of tariff heading, so you must know the tariff to know whether the 4-digit heading changes during your processing. And then you say also that there are certain exceptions. For example, in our case here, change of tariff heading, except for heading 8503. 8503 is parts for electrical motors. So if you have an electrical motor, but all the parts you are using, you are just putting them together, and these parts are not originating, then you don't meet the origin requirement. And then you have the second criteria, max norm, which we have also in the agreement with Japan. And max norm means the maximum value of non-originating materials. And so in this case, it's 50%. So you can't use more than 50% of non-originating material. And the only possibility, if in the UK you can't fulfill the 50%, you can then still use parts from the EU, which are originating in the EU. We call that bilateral cumulation in order to meet the requirement, but according to the current draft, you cannot cumulate with any other country like Canada, for example, or Japan, with whom the UK also has free trade agreements. So it's quite complicated, and it means if we have a free trade agreement, you need also a specialist, either in your company or outside your company, who determines whether your goods qualify for preferential treatment or not. And you cannot just put on your invoice that these are UK originating materials. By the way, we would need the text of the agreement anyway, because there's a precise text you have to use for this origin declaration. Next one, please. Yeah, the good news is just 1 or 2 days ago, the EU has published its transport contingency measures, and so there will be a basic air connectivity and a basic road connectivity. So during the first 6 months, the trucks or the airplanes will not be stopped because they don't fulfill certain rules. The same, by the way, is true for the Channel Tunnel. Also, the trains are allowed to travel. So that's good news, and this is independent from whether there is a free trade agreement or not. If there will be any problems, that will be later. Next one, please. Yeah, now next one is export from the EU to Great Britain. This is, of course, the majority of the clients I advise. So I tell you in a nutshell what's the normal process of an export, which is the same from to any third country. So there is nothing special here, but for some people who export for the first time, it's worthwhile to repeat it. So the exporter lodges the export declaration. This takes place normally at the place where he is established, and the goods must then be presented at the customs office of exit. That's normally a port, the Channel Tunnel, or a plane. Since the UK is an island, there are less options. Then, if there will be a free trade agreement, then the exporter can issue a proof of preferential origin if it is above 6,000 euro, then he needs to be an authorized exporter. Another possibility to get the goods to the UK is common transit, but again, common transit is then combined with an export declaration. It's just another declaration. And some people think it's a good idea to use common transit so that the goods can come from the exporter's premises to the premises of the importer. But in fact, one has to see that in a more nuanced way, because as we will see later, for a number of goods, the UK does nothing at the border. It just lets the goods pass under certain conditions. And if this is the case, then it's not such a good idea to use transit, because under the transit procedure, the Customs Office of Transit must be involved. And the Customs Office of Transit is, for an export from the EU to Great Britain, the first customs office at the border. So it's the one at the port normally. So that slows down the process, and you should be aware of that. Then, very important, the buyer must act as importer. Again, there are other possibilities, but I will explain later that it is vital that the buyer in the importing country acts as importer. So he must have an EORI registration. He or his representative then lodges the customs declaration before arrival, because if he lodges it at arrival, then it slows down the process at the border. The good thing is you can use in the UK entry in the declarant's records and then lodge 6 months later the customs declaration. But in order to be able to do that, you must have a duty deferment account. Yeah, and if you are dealing with excise goods, then everything is more complicated because union goods then need to be moved to the Customs Office of Exit under EMCS. And when they arrive in the UK, they can then also move under duty suspension. But again, you have to open the corresponding procedure in the UK. Or there for excise goods, using external transit is a good idea because then the goods can move from the trader's premises to the trader's premises in the UK, but of course then the person on the other side should be an authorized consignee. Yeah, next one, please. Yeah, what facilitations do exist? This is now quite technical, but you will receive the transparencies later so that you can read this more in detail. So there is the possibility of a single transport contract, and that's for railway companies, postal operators, airlines, including express couriers and shipping companies, so that the Customs Office of Export and Exit is the same. So you have to stop only once. But of course, this works only within the EU. So then the second move, then the formalities remain. And then we have the external transit procedure, which means that the export procedure ends when the transit procedure starts. But as I said before, this requires formalities at the Customs Office of Transit at the border in the UK. Why is that? If the goods get lost, we know then whether the goods got lost in the EU or in the UK. And if they get lost on the sea, then they haven't arrived in the UK, so we assume then that they got lost in the EU. Next one, please. Yeah, import into the EU. So this is where you can ask me every question, because that is my my specialty, EU law. So the first thing you need to do is but that is when I say you, that's the carrier. He lodges an entry summer declaration. And if it is a truck, the deadline is 1 hour before arrival. There is also a possibility to include this in the NCTS message if the member state to which you send that message can receive this, if the software exists there. Then, because otherwise you have to lodge an entry summary declaration. And please don't consider the EU as one block. The entry summary declaration has to be lodged to the Customs Office of Entry. Yeah? So where you will arrive, that's where you have to lodge your your entry summary declaration. Then the next step is the importer or his representative lodges the customs declaration and submits any required documents. And again, this should be done well before the truck starts, so that by the time the truck arrives in the EU, everything is available and a choice has already been made whether the goods will be checked or whether any documents have to be stamped. Yeah, so when you arrive, you have to say, I have arrived, and this is also an electronic message with certain data elements. For the moment, the presentation notification is not harmonized yet, so in every member state, the way you present your goods to customs is different. Then the next one, this fortunately is largely harmonized. The goods must conform to EU standards. Again, that you should have, of course, checked already beforehand. And there must be a person established in the EU who is responsible for product conformity. And that person must also be indicated either on the goods or on the accompanying documents. All these are things you must do well before you actually do an export. Yeah, and then the question of payment comes. Even if we have a free trade agreement, there will be still import VAT, there will be excise duty, and there will be also customs duty for all the goods which are not qualifying for duty-free treatment. So that is what you have to think about. Then for VAT, you have certain options. You have the Customs Procedure Code 42. For example, if the goods arrive in France, but they are destined for Germany, then you can use the Customs Procedure Code 42, which means there is no import VAT. You don't need to be registered in France for this import. Then the importer can have VAT accounting under the general VAT declaration. Again, the conditions vary from member state to member state. But for example, in France, this is possible. In the Netherlands, there's something special on which I will talk a bit later. And so that you don't lose, or the importer doesn't lose too much cash by paying upfront. This needs to be planned very carefully. Yeah, and if the duties have been paid or the duties have been guaranteed, then they are released, provided all these requirements are met. And then, of course, to my EU clients, I say, okay, and decide or consider whether you shift to an EU supplier, because all this extra hassle you can avoid by buying in the EU rather than from the UK. Next one. Yeah, I show you now two obstacles which could prevent the goods from being released. There are many more, but just two of them. So you need the common veterinary entry document for meat, for example. And this document has to be entered in the TRASIS system after control. It consists of two parts. The first part must be completed by the importer, and the importation must be pre-notified. And the second part is then completed by the veterinary services. And there are border inspection posts where you must present your goods. So you cannot take any port. You must make sure that there is a border inspection post for the goods which fall under this regulation. Next one. This just shows you how the document looks like, 2 pages, so lots of information. As I said, 1 page to be filled in by the importer, the second page to be filled in by the veterinary inspection. Next one. Yeah, and now another one, a good one, because here the formalities can be fulfilled already in Great Britain. I have copied this from a regulation which was just published 2 days ago, and this is independent from any free trade agreement. So for fruits and vegetables, the British authorities can certify that fruits and vegetables are according to the marketing standards, because the marketing standards are equivalent to those in the Union. That makes me smile, because the UK says they want to take back control, but for fruits and vegetables, they have accepted to apply the same rules as the EU, which is a good decision because now the goods will be treated largely as if they have been made in the EU, provided this mark is there, that the certificate is there, which I will show you in the next one. Next one, please. So a certificate of conformity accompanies the fruits and vegetables, and then they can come in. They may still be controlled, and if during the short travel they have rotten in the meantime, they can still be rejected. But in the large majority of cases, the fruits and vegetables, if they have this certificate, they will just go through. Next one. Yeah, and now my big advice. Why is DDP wrong for GB sellers to the EU? Because DDP means delivered duty paid, and in the negotiations, what is happening now on both sides, importers in the EU say, I don't want to have any trouble with customs. Why don't you do the clearance for me? And it is a huge mistake to accept that because there are a number of very serious disadvantages. The first one is if you don't have a permanent business establishment, then you cannot lodge an import declaration. So you need to find an indirect representative in the EU. And he will, of course, ask for more money because he takes on additional risks. Second one, under the EU product conformity rules, you need a person established in the EU anyway, who is responsible within the EU. So if you don't have that person, you can't even import. And under the REACH regulation, which is on chemicals, there are even more restrictive conditions. So for all products with conformity rules, it's you need someone in the EU anyway. And then there's another point which many people overlook. The moment the importer is not established in the EU, but the importer is established outside the EU, and that's the case if you lodge the declaration under DDP, then there is the import VAT and the regular VAT. And in order to get your VAT back, which is 21% in Belgium, for example, that's quite an amount. You need to be established. You need to be registered for VAT in the EU, or you have the very cumbersome refund procedure where it takes a long time until you get your money back. So, the fourth disadvantage is you will be required to be registered in every member state in which you import. There are a number of ways around this so that you can avoid being registered in all member states. The standard way around this is the use of Customs Procedure Code 42, but that obliges you then to choose carefully which port you are using. So if you are selling to France, then you have to use a Belgian port, and if you are selling to Belgium, then you have to use a Dutch port or a French port. So that makes your process quite complicated. The best way is just to avoid this. Another way around this is to sell DAP, delivered at place, and the place is the place where the customs office at the entry in the EU is. And in addition, your client must then accept that he authorizes the import declaration. Then de facto he is the importer. But you as a British exporter, you then tell him, I will pay for the customs clearance and I will pay for the customs duty. I will not pay for import VAT because you can deduct it as my client. It takes a bit more time to explain this to the client, but it is worth the effort. Next slide, please. Now trade from the continent with Ireland and Northern Ireland, that's also very important, because people tend to continue what they have been doing in the past. And that is quite often the wrong approach, because today, of course, you can bring goods which are destined for Ireland or Northern Ireland. You have a truck, the truck goes to the Channel Tunnel, and then through the UK, through England, and then to Ireland. It's called the so-called land bridge. This, as of 1st of January, will create a number of complications, because you either need a transit procedure. You always need a transit procedure, at least a British one, because you don't want to pay the duty in Great Britain. And from the EU side, you can then use the common transit procedure. So that's not a good idea. So whenever you can avoid it, try to find a direct travel from a port, for example, in France to Ireland. And if it is a regular shipping service, then you don't need any documents. If it is a shipping service which also goes to a port in Great Britain, but doesn't unload your goods, then you need a T2L document. I have all the references here on the document which you will receive later. So that's the procedure. But as I said, if you can avoid it, avoid it. Next one, please. Yeah, what other questions do you have to examine if you import from Great Britain? So you have to check your authorizations. Do they cover your business with Great Britain, or do they need to be extended? Are your reference amounts and comprehensive guarantees sufficient? And this, by the way, is independent whether there is a free trade agreement or not. It's always necessary. If you have deferred payment, do you have to increase your amounts for temporary storage, your customs warehouse for inward processing? Is your ERP system adjusted because there are new items and new processes? For example, you need to differentiate between origin in Great Britain and origin in Northern Ireland, and also where the goods come from. Do you have all the documents relevant for customs purposes? So you need to know, where do I classify goods in the tariff if they come from Great Britain? What's their value? Because it's not only the price, I have to add the transport cost, for example, the insurance cost. Do I have this information, and do I keep it suitably when the customs audit inspector comes? Are my certificates and authorizations issued by the wrong authority? If you are in the EU, they must be issued by EU authority. If the goods go to the UK, they must be issued by a UK authority. Things like that, including binding tariff information. UK binding tariff information is no longer valid in the EU, and the same in the other sense with regard to Great Britain. Are my products properly labeled and marked? So in the EU, we have the CE sign. In the UK, for a transitional period, the CE sign is still accepted, but later then the UK according sign must be used. Next one. Okay, this is just the CN 22 and CN 23 declaration, just to make to show you. There are further documents which you didn't need in trade with the UK before Brexit. Next one. Yeah, since there is a severe lack of experts in the UK, it is of course important to consider how can I support my business partners in Great Britain? So EU companies already exporting, they will have no difficulties, but in the UK, there are lots of companies who are importing or exporting for the first time, and then one can think about how you can support them if you are in the EU. So the easiest it is for multinational companies because they can then just transmit their export declaration data to the other side of the channel, and so that they can prepare the import declaration. And if they have an interface and a good IT system, they can then lodge the declaration both into the system of the EU member state and to chief, provided the person lodging the declaration is established in Great Britain. So that's a requirement. But so for multinationals, for them it's the easiest. Next one. But also non-affiliated companies can support their business partners. For example, they can use their existing export declaration and then fill it in the required UK declaration if they have the staff and the software, and then they send this either to their business partner or to his customs broker, who then enters it into chief. Yeah, and another alternative is a service provider who prepares the customs declaration data on the basis of the information derived from existing documents, and then sends it to a customs broker in Great Britain, who then forwards them under his responsibility to chief, or in future to CDS, the customs declaration system. Because the important thing is you cannot just prepare a customs declaration even if you have all the data. You must also be able to send them then to the customs declaration system, and for that you need an interface and you need to be admitted to the system. Yeah. You have all these options, and the importing and exporting companies should consider in good time which of these solutions they want to apply. Yeah, next one. Okay, here I have shown you the transit process, which starts with the export declaration, then you have the transit declaration, and then you have the export declaration, and and then you have the import declaration. So there are a number of formalities to be fulfilled in future. Next one, please. Yeah, get ready. I will be brief because our time is advancing, and I want also to leave time for questions and answers. So the first thing, the UK puts it as third step, but the first thing is you need to have an AORI number, because without that you can neither import or export. And then you have to check what are your rules you have to apply, since the UK is introducing its system in 3 phases, so that you have to check. Okay, well, the tax or the duty you will have to pay. Okay, that today you cannot even check because we don't know yet whether there is a free trade agreement or not. So the fourth step you can't do yet. Only the VAT you know already, but that's the same if you buy the stuff in the UK. And then check if you can make the importing process quicker. That is, of course, very important, because the UK offers a number of options, and that is really important for you to check. So if you have an AORI number, I would say the 5th step is the most important one for you. How can you speed up the clearance process and all the things which the UK is offering? You should make use of it, especially the possibility of entry in the declarant's records and the customs declaration only 6 months later. This is a marvelous offer, which of course will later disappear. Next one. Yeah, okay. Most of you have looked at the border operating model, so I will not speak a long time about that. So for standard goods, there will be no decorations required, except that, of course, for your truck, you must have some information which I will treat later, so that the truck can pass. So that's important. And what is also important is you need a deferred payment account so that you can make use of this possibility. Next one. Yeah, for controlled goods and excise goods, you need to make standard declarations. If you are not able to do it yourself, you have to find a service provider. And also for export from day one, you must make export declarations. So also, if you are not able to do it yourself, also you need a service provider. Next one. Yeah, then from April 21, products of animal origin will require pre-notification and health documentation, and physical checks will continue to be conducted at the point of destination until July. And then July, then the final situation arrives. You have to make full customs declarations at the point of importation and pay the tariff. So, of course, the possibility of deferred payment will also exist. And then there are sanitary and phytosanitary controls already at the border. So that's the UK border operating model according to the current publications. Next one. Yes, this one I will treat very briefly because this is the new system which the UK is introducing, the Goods Vehicle Movement Service, which means every truck must be announced beforehand, and it will be necessary to link the goods on the truck to the declarations which have been made, or the possibility that entry in the declarant's records is taking place. So this is something, if you are importing into the UK, you must study very carefully. You are affected by it. The important thing is you must be registered, and the important thing is also, if you don't have the barcode or you don't have the booking reference number, you will be stopped and you can't enter. So it is very important that you respect these rules. Yes, next one. So this is the complicated process. Okay, and for travel of animals, next one, there are also special rules. So I will now briefly talk about the preparations in France. They have created something which they call a smart border, which in principle is nice, but again, it requires that you have the software to enter into the French system. And you have to do all this before the goods arrive, so that on your arrival, you know I can pass, or whether I am subject to controls. They call that anticipation. You declare everything before arrival. You identify yourself when you arrive, and you are then either going to the place where you can go through, or you are going to the place where you're going to be checked. It's a nice system. Next one. Okay, and the key point is everything is communicated beforehand. Next one. Yeah, this is in more detail, which you can study then later. Next one. Next one. And you see there's many of the things you can leave to your logistics expert. Next one. Next one. And so the French work very much with a barcode. So the trader must have the truck driver must have the barcode, which allows then French customs to access all the declarations related to that barcode. So that is very important. Okay, and for postal items, there are special rules. There are special rules for meat and for animals and for fish. So all that you need to know. Next one. So again, on export also, this works with barcodes. Next one. So that's quite nice. You have to anticipate well before you arrive at the port or at the Channel Tunnel what you're going to do. Next one. Okay, I will go over Brexit over Belgium, except the last one. Please go further. So this is now the procedure in Belgium, which is slightly different from the one in France. Next one. Yes, at least they have a common community system. So for all ports and airports, the system is the same. That's good to know. Next one. Yeah, that's a nice thing in Belgium. In Belgium, they are saying if you infringe the rules during the first 2 months and you didn't do it intentionally, then they will not sanction you. That's the positive thing. Next one. So now for the Netherlands, briefly. The Netherlands have also automated this, but again, you must now link to the relevant Dutch system, and you must have it for the relevant port, which you have to pre-notify with your customs documents. Next one. So in the Netherlands, like in any other member state, you must now have an EORI number. You must be able to submit your declaration to the Dutch system. You must have message exchange. All this you should, of course, have arranged already before the Brexit. Next one. So they have called it in 5 steps: register with customs, decide who submits the declaration, because it's either you or it's a service provider. Who will pre-notify? You have to be linked to the port-based services, and you must check whether you are able to ensure that the terminal has the documents prior to departure. Next one. So, okay, these 5 easy steps are explained more in detail, but we skip over that. Next one. And next one. Yeah, and then, of course, veterinary inspection points. That's a very important one, because only certain ports have veterinary inspection ports. So if such inspections are necessary, don't send your truck to a place where there is no inspection point. Next one. Next one. Yes, and here a closing remark. One difference between the Netherlands and the other member states is that in the Netherlands you don't need to use Customs Procedure Code 42, where you're then obliged to use a different port according to the member state of destination. In the Netherlands, you can use a Dutch freight forwarder with an authorization according to Article 23 of the VAT, the Dutch VAT law, which allows then postponed accounting for VAT. And you don't even need to register in the Netherlands for that, because your Dutch freight forwarder and customs broker will do it for you. Next one. Yes, and now I come to the final part, the special situation of Northern Ireland. If goods arrive from Great Britain to Northern Ireland, in Northern Ireland an import declaration is required. Again, that should be lodged before the goods arrive in Northern Ireland. The UK has established a trader support service for the completion of customs formalities, which is free to use, but you must have some knowledge of customs nevertheless in order to be able to fill in such declaration. Yeah, then if the goods are not at risk of being diverted to the EU, they are then duty-free, provided, of course, they are in free circulation in Great Britain. So you can't use Chinese goods and then just send them to Northern Ireland. They must then first be released for free circulation for that. And then there will be a new UK trader scheme. We don't know too much about that yet, and where that will then make sure that the goods will remain in Northern Ireland and not forwarded, for example, to Ireland. And if the goods are at risk because it's not sure where they will go, then the EU import tariff will have to be paid. Or again, there can be deferred payment. And then there are special rules for commercial processing that are goods which are going from Great Britain to Northern Ireland, are then processed and then are getting back. For example, you have big cheese pieces, and then you slice them, put them in small packages, and bring them back to Northern Ireland. But my advice would be don't make it so complicated. Do it in Great Britain. That's easier. And then there are restrictive products like meat, all things subject to health controls. Then there will be a movement assistance scheme for agri-food traders. That you have to study in order to fulfill this. So it will be more complicated to bring goods from Great Britain to Northern Ireland. And often you will also have to, or in certain cases, you will also have to pay customs duty. Of course, if there is a free trade agreement, that would, of course, reduce the number of cases in which you would have to pay customs duty. Next one. Yeah, and now the other way around, goods moving from Northern Ireland to Great Britain. In a number of cases, you will have to lodge an export declaration, especially for goods which are not in free circulation. Then it's called re-export declaration, and also for goods subject to restrictions. Then for goods which are in free circulation in Northern Ireland, then the UK has introduced the idea of goods with qualifying status. They can enter Great Britain without any formalities. That, of course, raises concerns that Northern Ireland can be used as a hub for EU traders for duty-free imports into Great Britain. That will lead to quite some discussions in the UK later. Then the UK has been so generous to extend this also to goods arriving through Irish ports. But of course, from an Irish port, you must always lodge an export declaration in Ireland. And then we will have interesting discussions on the anti-avoidance provisions to tackle EU businesses who route their products through Northern Ireland to avoid the UK customs tariff. And this will be done by identifying qualifying traders as they check in at ports and airports in Great Britain, which then means that there will be controls of goods in UK ports, in Great British ports and airports, because you have to know, are they coming from a qualifying trader or a non-qualifying trader? Yeah, and then non-qualifying goods will be subject to the UK's import process and customs duty for third country goods. So life will become more complicated, and everybody doing such business should have an understanding of customs rules. Yeah, next one. Yeah, and then goods, the good news for goods moving between Northern Ireland and Ireland is that they can move freely, because Northern Ireland is for the movement of goods within the treated as if it is the 28th member state. So you can also use Customs Procedure Code 42. For example, you can release goods for free circulation in Dublin and then bring them to Belfast, or the other way around, and that is without payment of import VAT. The EU VAT directive applies, so that you can use the reverse charge mechanism if you sell goods from Northern Ireland to Ireland and the other way around. The excise duty, the excise directive applies, so you can send tobacco products from Dublin to Belfast under duty suspension under the EMCS system, and you have to lodge intrastat declarations if you are above the threshold for movements, for example, between Northern Ireland and Ireland. Yeah, I now come to the end of my presentation, and I'm now looking forward to your questions.
So, Michael, thank you very much. We have a number of questions in the